And we should be back live. Let's see. Daisy May, what's going on? What's going on? Good to see you. Good to see you. I've been that's 2 in a row for We the People News today. Thought about going live on exposing the tyrants. Because I really do think that this is about exposing the tyrants. I really do. And I think that there's not enough people that either don't care or they're just not seeing it. I don't know which of the two. I do know that people don't tend to care unless it's happening to them or unless it's happening to somebody that's close to them. But I will take this moment to remind the public, remind those watching, how big of a case this is and the impacts that it will have on others if they are able to get their way. So, Your Honor, and to the public listening, this case is about whether a journalist can be silenced for reporting on his own government. The document I'm about to read, the defendant's opposition to the government's motion for a protective order, goes to the heart of that question. The government is asking this court to impose sweeping restrictions that would stop me from even possessing or discussing the evidence in my own criminal case. They call it a protective order, but in practice, it's a gag order, one that strikes at the First Amendment and the public's right to know. This prosecution began after I published evidence obtained lawfully through a FOIA request showing that U.S. Marshals had circulated a BOLO alert placing me under surveillance for my journalism. 2 days later, I was arrested while peacefully protesting on courthouse steps, filming the very government that was watching me. Now those same agencies want to hide behind a claim of security, even though much of the material they seek to restrict has already been released publicly through FOIA and my reporting. The filing argues that there is no good cause for this level of secrecy under Rule 16 of the Federal Rules of Criminal Procedure, and that any legitimate concerns about courthouse safety can be handled through narrow, targeted measures, not a blanket muzzle. What's at stake is larger than my own defense. It's whether transparency still means anything when the press itself becomes the defendant. The Constitution demands sunlight, especially when power wants shadows. So as I read this opposition, listen for 3 things. The law. Rule 16d1 requires a specific showing of harm, not speculation. The facts. The government's sensitive information is already public. The principle that no journalist or citizen should be barred from speaking truth about their own prosecution. This isn't just a legal filing. It's a stand for the First Amendment in real time. And I'll say this also before I get started with this opposition, that my attorney was nice. He was overly nice. This is not what I sent him. He actually proposed alternatives that honestly don't sit very well with me, because I believe wholeheartedly in transparency on this situation because of everything that's come out. There should be absolutely no middle ground on this. So I'm just going to say this, that's the best the government's going to get, was what he filed here in this matter. I think I sent him 160 pages of stuff for filings that got compressed down to 10. But it's very important, the things that he did put in these 10 pages. So this is the United States of America versus Matthew Reardon in the Western District of Louisiana. Now into court, through the undersigned counsel, comes the defendant, Matthew Reardon, who respectfully opposes the government's motion for a protective order, document 23, and the continuation of the interim protective order, document 24. For the reasons set forth below, the protective order should be denied in its entirety, or alternatively substantially narrowed to address only legitimate security concerns, while preserving Mr. Reardon's constitutional rights in the public's interest and transparency. The introduction. The government seeks a broad protective order that would prevent Mr. Reardon, an investigative journalist with over 3,000 subscribers, it's actually over 8,000, from possessing copies of or even publicly discussing evidence in his own criminal case. This prosecution arose from Mr. Reardon's constitutionally protected activities, documenting his interactions with federal law enforcement and protesting what he discovered through FOIA to be unlawful surveillance of his journalism. Now the government seeks to compound its violation of Mr. Reardon's First Amendment rights by imposing a gag order that would prevent him from informing the public about the evidence underlying this prosecution. The very materials the government now seeks to shield from public scrutiny, Mr. Reardon believes are central to understanding the government's improper motivation in bringing this case and the retaliatory nature of the prosecution. While undersigned counsel recognizes the court's paramount obligation to ensure courthouse security and the specialized expertise of the U.S. Marshals Service in security matters, the government has failed to demonstrate good cause for such sweeping restrictions. Its vague assertions about courthouse security and sensitive law enforcement information cannot justify the requested relief. The protective order should be denied or substantially narrowed. The factual background. Mr. Reardon is an independent journalist who operates the We the People News platform, documenting government activities and advocating for government accountability. His journalistic work is consistently focused on exposing government overreach and protecting constitutional rights. Through a Freedom of Information Act request, he discovered that U.S. Marshals had placed him under surveillance through a BOLO, Be on the Lookout alert, based solely on his protected journalistic activities. When he attempted to file a complaint about this surveillance at the Lafayette Courthouse, he was turned away and told to contact Washington, D.C. Within the trove of FOIA documents he received from the government were numerous emails between the U.S. Marshals and courthouse staff. 2 days before the events that led to this case, Mr. Reardon lawfully published the documents he received from the FOIA request on August 23, 2025, on his news website, We the People News, WTPnews.org. This publication included the very emails the government now seeks covered by the protective order. On August 25, 2025, Mr. Reardon exercised his First Amendment rights by peacefully protesting this government overreach on the courthouse steps while documenting the event for his journalism platform. The government responded by arresting him and seizing his equipment. Mr. Reardon has already published video of these events on his YouTube channel, making much of the supposedly sensitive information public. The government now seeks to prevent Mr. Reardon from possessing or discussing additional evidence, claiming that discovery materials contain sensitive, courthouse security operational plans, and communications between the Marshal Service and federal judges. The government provides no specific identification of what materials are actually sensitive or how disclosure would cause harm. More importantly, it appears that the materials referenced by the government were already released to the public via the above referenced FOIA response and subsequent publication. The legal authorities. Protective orders under Rule 16d1. Federal Rules of Criminal Procedure Rule 16d1 permits protective orders only upon a showing of good cause. The party seeking the protective order bears the burden of showing good cause. United States v. Carrillis. Good cause exists when a party shows that disclosure will result in a clearly defined, specific, and serious injury. A finding of harm must be based on a particular factual demonstration of potential harm, not on conclusory statements. United States v. Smith. When considering a protective order, the courts must consider whether the imposition of the protective order would prejudice the defendant and should seek to ensure that disclosure of discovery materials to a defendant involve a minimum hazard to others. Courts must also balance the public's interest in the information against the injuries that disclosure would cause. B. The First Amendment is a relevant concern when examining a protective order. The Supreme Court has held that the press and general public have a constitutional right to access to criminal trials. Globe Newspaper Co. v. Superior Court. Apart from a constitutional right of access to court proceedings and documents, the Supreme Court has held that the public has a common law right to inspect and copy public records and documents, including judicial records and documents. But these constitutional protections have not been extended to discovery. Seattle Times Co. v. Reinhart. Nevertheless, examining a protective order under the framework of Rule 16d does not eliminate the First Amendment as a relevant concern. Rather, the existence of the protective order confines First Amendment scrutiny, including defendants' right to disseminate the discovery material, to the framework of Rule 16d's good cause requirement. The argument. The government fails to demonstrate good cause. The government's motion relies on generalized speculative assertions about potential harm without identifying specific sensitive information or articulating how disclosure would create actual security risk. Based on the undersigned's review of the discovery materials to date, many of the government's claims of sensitivity appear overstated. First, the government fails to acknowledge that Mr. Reardon live-streamed the events in question and had already lawfully published the FOIA documents that included communications between U.S. Marshals and courthouse staff. Thus, most of the facts surrounding this case are already public. Second, the government claims the protective order is necessary for materials that may tend to reveal the methods or operational behavior of the U.S. Marshals in performing its courthouse security function. While the government is entitled to protect truly sensitive security protocols, it is not specifically identified which materials contain such information or how their disclosure would create a genuine security risk. Nor does the government claim that any particular security measure would be compromised, that any individual would be endangered, or that any ongoing operation would be jeopardized. From counsel's review of the discovery provided thus far, the materials appear to consist primarily of Mr. Reardon's own video recordings that have been published online, video recordings of Mr. Reardon in a U.S. Marshal holding cell and receiving medical attention. Email communications regarding the incident that do not appear to contain detailed security protocols. Standard incident reports documenting the interaction with Mr. Reardon. Documents related to the Bolo alert that Mr. Reardon has already obtained through FOIA and published. While undersigned recognizes that security professionals may identify vulnerabilities not apparent to defense, the government bears the burden of specifically identifying what materials require protection and why. It has not done so here. Additionally, the discovery appears to contain no personally identifying information, P2, beyond Mr. Reardon's own information. If the court determines that some level of protection is warranted, the undersigned requests that any order be narrowly tailored to address only the specific materials that genuinely implicate security concerns, rather than the blanket restrictions requested by the government. Third, Mr. Reardon has already published extensive video documentation of the August 25th incident on his YouTube channel. Viewed by thousands, Mr. Reardon has already published records from the FOIA request showing communications to and from the U.S. Marshals to courthouse staff. In fact, it appears the FOIA documents included more U.S. Marshals emails than the discovery documents turned up. The government cannot claim sensitivity for information already in the public domain. Moreover, undersigned is mindful that protective orders are appropriate in many situations, and that maintaining courthouse security is a legitimate purpose for a protective order. Undersigned, however, fails to see any documents in the discovery, in this case, that disclose any operational or security information that is not already public or widely known. Courthouse security procedures are necessarily observable by the public. Every day, citizens pass through courthouse security, observe martial procedures, and interact with court security officers. These publicly observable procedures cannot be deemed sensitive merely because they are documented in discovery materials. The public interest strongly favors transparency. This case raises fundamental questions about the boundaries of First Amendment protection for journalists at federal facilities, the use of surveillance, BOLO alerts against citizens engaged in constitutionally protected activities, the prosecution of individuals for documenting and criticizing government conduct, and the response of federal law enforcement to accountability journalism. The public has an overwhelming interest in understanding the evidence underlying such a prosecution. Transparency serves not only Mr. Reardon's defense, but also the public's ability to evaluate whether the government is respecting constitutional boundaries. As the Supreme Court recognized, the First Amendment goes beyond protection of the press and the self-expression of individuals to prohibit government from limiting the stock of information from which members of the public may draw. First National Bank of Boston versus Bellotti. Less restrictive alternatives would serve any legitimate interests. Even if the government could demonstrate some need for protection, which it is not, the proposed order is far broader than necessary. This court should adopt the least restrictive means of serving governmental interest. Less restrictive alternatives could include: 1. Targeted redactions that remove specific sensitive information so that the documents could be released with the redactions. And actually, that's not okay with me. I'm gonna keep appealing and appealing and appealing until there's no redactions. We will wrap this thing up in red tape and draw it out for a long time. I don't care. Or 2, tiered disclosure that would allow full disclosure of non-sensitive materials while restricting only materials containing demonstrable security information. The government has not explained why these less restrictive alternatives would be insufficient. If the court determines that some form of protection is necessary, undersigned proposes the following narrower protective order that would address legitimate security concerns while preserving Mr. Reardon's constitutional rights. Number one, the government shall specifically identify which documents or portions of documents contain sensitive security information with a brief explanation of the security concern implicated. Two, defense counsel may challenge the designation of specific materials, requiring the government to articulate with greater specificity why those materials require protection. Three, for materials containing genuinely sensitive security information, Mr. Reardon and his counsel shall not publicly disclose the specific security protocols, contact information of security personnel, or technical details of security systems. However, Mr. Reardon may discuss and possess all other evidence related to his case, including video recordings he made during the incident, communications related to the Bolo alert, any information already available through FOIA or other public sources, the general circumstances of his arrest and prosecution. Rather than requiring all discovery to be maintained only by defense counsel, the court could require specific security-sensitive documents to be maintained securely, while permitting Mr. Reardon to possess non-sensitive materials. This approach would protect legitimate security interests while avoiding a restraint on Mr. Reardon's speech about his own prosecution. Conclusion: a journalist prosecuted for documenting government conduct should not be gagged from discussing his own case. The protective order represents a continuation of the very suppression of speech that led to this prosecution. It should be denied in its entirety. Respectfully submitted, Rebecca Hudsmith and Dustin Talbot. So, and I'll post the, I've already posted. It's on, I believe I posted the document on YouTube. I know I posted it on Facebook, and I'll be putting an updated article on We the People News website, WTPnews.org. You will be able to actually read this motion or this response here shortly if you've not. Okay? This has gone from a more localized issue to a mainstream national issue because of what's at stake, because of what the United States government has done through its U.S. attorneys, through the Department of Justice. If it wants to change its name, and it's that I've given it, from the Department of Corruption, maybe it should stop immediately acting in corrupt ways, trying to cover up something so important as ex parte communication that took place between U.S. Marshals and federal judges 2 months prior to them violently attacking me, arresting me, and charging me with this petty crime. And to think that they can actually get away with keeping that hush on who the federal judges were that were in receipt of these emails that the U.S. attorney, the U.S. government have already admitted took place. We knew it was there. I saw it well in advance, pointed it out on live streams. Okay? knew it was there. And there's a plain admission in the motion for a protective order that this did take place by the U.S. attorney. It's bold. The steps that they are taking right now are bold, so bold. So bold because they're counting on exactly what's going on with this live stream. They're counting on the people not seeing it or not caring. And they're doing it right under your eyes, folks. Like they're not even trying to hide it. This is flagrant. It is out in the open. And I've been trying to make as much racket about it. And I see a couple people drop off and all that. And I'm going to be the guy that's sitting here saying that I told you so when it does happen and this precedent is set. Because I tried my damnedest to blow the whistle on this and to call foul. The information's out there. I've done everything I can to put it out in as many places as possible. I'm willing to clash with this unconstitutional order head on if I have to, because I'm not letting it fly. But you know, it would sure it would go a long ways for we the people, for the people to get behind this and to put eyes on this, to redress, to let the government know that you care, that you're aware, and that this won't be tolerated. So it's all in the court documents. I've published the proof through the FOIA. Keep it circulating, because they can't try to silence. They can't turn over the evidence. They can't provoke their own prosecution and then turn around and try to cover up their wrongdoing. They just can't do it. It's nasty. I'm going to file a slew of complaints in this. And the best thing that they can do is mitigate the damage and toss the bullshit out. Because I haven't even started exposing yet. And that's going to go up to a whole nother level before everything's said and done. Thank you all for tuning in. I got that article with the Mississippi Department of Corrections. All right. The flame has been lit on prisoner conditions in Mississippi, on basic constitutional rights being deprived to inmates. I witnessed it personally myself while I was there, and I have sources on the inside that are telling me exactly what it's like right now. If you didn't catch that live stream earlier, where I discussed everything, what happened with my call to the Mississippi Department of Corrections Commissioner yesterday, check out that live stream. It's right here on the We the People News YouTube channel. I'm also going to end up putting that on the article that I published tonight. Actually, the article that I just published, I need to go over there and put that video on there. So I'll do that right now when I end this live stream. Thank you all for tuning in. This has been another We the People News special update. I am the one and only Don Matthews, aka Matthew Reardon, aka the Oxford Outlaw.